Give me a moment here and let me get this live stream started. Okay, you're free to proceed.
Okay, thank you. All right, everyone. Welcome to the December meeting of the Rehoboth Beach Board of Adjustment. We're conducting this meeting virtually due to the COVID-19 pandemic. Our thanks to Joe Gaccio for his help in producing this virtual meeting for us. I want to take this opportunity to introduce our newest board member, Jan Connessy. Jan has had broad experience in city government. She's been a member of the city commissioners, and she's also been a member of the planning commission. So she brings vast knowledge to the operations of city government. Welcome aboard, Jan.
Thank you.
I also want to note that Ann Womack, our diligent clerk, will not be here today. So I'll be filling in for her to the extent that her clerical input would be required in this meeting. So wish me luck. Now on to the business of the day. This afternoon, the Board of Adjustment will be considering two cases. Our first case concerns 16 Hickman Street. This case is an appeal from a decision of the building inspector. The property owner wants to replace an exterior stairway at the rear of the property. The building inspector has declined to issue a permit for the replacement stairway, and the property owner also replaces all doors and windows located within 10 feet of the replacement stairway. The building inspector is requiring that the replacement doors and windows meet the standards of the fire code. The second case we're going to hear is a request for an area variance at 46 Sussex Street. The homeowner seeks to install a bay window, which, as designed, would partially encroach into the rear yard setback. This is the point of the meeting where I would ask Ann to tell us about her efforts to provide the public with legal notice as to these two cases. I'm going to read into the record the report which she prepared for me on the subject. According to Ann's memo, the agenda for the Board of Adjustment meeting was posted by Ann Womack, City Secretary, in City Hall and on the city portal on December 14, 2020. The public notice for case number 1120-07 for the property located at 16 Hickman Street was posted in City Hall and on the city portal on December 1st, 2020. The public notice was published in the Cape Gazette on December 4th, 2020 and December 8th, 2020. Coast Press on December 9th, 2020, and the Delaware State News on December 3rd, 2020, and again on December 4th, 2020. Notification specific to this case was mailed out to property owner addresses within 200 feet of the subject property, and signage was posted on the property. Now we'll move on to the next one. The public notice for case number 1120-08 for the property located at 46 Sussex Street was posted in City Hall and on the city portal on December 1st, 2020. The public notice was published in the Cape Gazette on December 4th, 2020 and December 8th, 2020, with the Coast Press on December 9th, 2020, and the Delaware State News on December 3rd, 2020, and again on December 4th, 2020. Notification specific to this case was mailed out to property owners' addresses within 200 feet of the subject property, and signage was posted on the property. Therefore, it appearing that all proper notifications were provided, we're prepared to go forward and hear the first case. So the first case is the Hickman Street property. If there's anybody out there listening or watching in, I want to thank you for taking an interest in our cases today. If you have requested time to speak, we ask that you address the issues before the board And by that, I mean the legal criteria for variances, which we will be discussing with you. We also ask that you refrain from making comments that have already been made by other speakers. Please note that we do have a court reporter present. For her to do her job, it is important that she be able to hear what each speaker has to say. So please keep your voices up, and please no cross conversation during the hearing. And like in court, all people who choose to speak will be required to give their testimony under oath. And I'm going to ask our attorney, Mr. Townsend, to administer those oaths. So thank you for your attention to the remarks, and now we can start. So this is the Hickman Street case. Mr. Building Inspector, you want to tell us about your case, or is Mr. Mandalis going to handle that for us?
Mr. Janis will be reading his report.
Okay.
Thank you.
All right. Good afternoon, everyone. So this is in reference to case 1120-07. It's 16 Hickman Street. And Mr. Chairman, if you would wish me to read the entire report, I certainly can. Or if you just like to go through the hit points of this and examine the exhibits, we certainly can approach it that way as well.
Why don't you hit the main points? Okay.
Thank you, sir. The nature of the request is, as stated, it's a replacement of an existing rear stairs. It's important to note that upon original application, the applicant decided to go for a variance to increase the size, increase this stairway before actually applying for any building permit to get that enlargement. So he decided to go right away with the variance request. It is a request to, again, to increase the size of that rear stairway that we have deemed as a secondary or as another means of egress as the building sits currently when it was converted to a commercial property. And the fact that it's over 3 dwelling units is what makes this a commercial property and not a residential dwelling. So, and the Board of Adjustments approved the increase on July 27th, 2020 of this year. The application was then filed August 17th, 2020 for a building permit to complete the work of the enlarging stairs as permitted by the Board of Adjustment decision. Subsequently, the application was denied by Chief Building Inspector Official Don Molina on October 5th, 2020, after being instructed by the applicant to withdraw the application so that the owner could pursue an appeal of the building inspector's decision. That email is provided in Exhibit B, which we will go through. As a matter of fact, let's just take a go ahead and look at Exhibit A. Is just a great representation of the stairs themselves as they exist today without being replaced. These are the stairs in question that the board granted variance to increase the size of. This is the existing stairs and obviously not the new construction. Exhibit B, which I just touched upon, is email back from Mr. Kanya, basically saying that he's withdrawing the permit and he wants to move on with the appeal of the building inspector's decision. Also, the email that was sent back from Don Molina describing all of his options, etc., that he could go through if they choose to go through with the construction of this and not seek variance or an appeal of this decision. The building official determined that the increase in size triggered other requirements under the international existing building code considering emergency egress and secondary means of egress. Rather than being submitted, this is an interesting point here, rather than being submitted as a multi-family building, the project was submitted to the Office of the State Fire Marshal as a single-family residential construction and reviewed as such. As the OSFM was unaware that the property had been converted to a multifamily condo units. If properly submitted as the multifamily building, the OSFM would have subjected the project to other code requirements applicable, which is noted in Exhibit C, which would be emailings between Don Molina and Denny Pridgeon of the State Fire Marshal's office. Basically goes back and forth to say, in the very top line of the very beginning of the email, as the building code and life safety code appear to parallel on the rating, you should enforce the requirements of the building code, as I only looked at the stairs as presented for review. Again, that was applied as only a single family application and not a multi-family application. The Office of the State Fire Marshal and the City of Rehoboth Beach have a memorandum of understanding, which is Exhibit D, that basically states whatever stricter code will apply, and each agency will help each other in determining those regulations and specifications. This was enacted by current city manager Sharon Lynn, former building and licensing supervisor Terry Sullivan, and State Fire Marshal Grover P. Engel on July 1st in 2014. So we've had this memorandum of understanding for quite some time. The relative code sections and review that would apply to this application. The project was reviewed under 2018 International Existing Building Code. It specifically falls into Chapter 6, Classification of Work, designates this project as an alteration level 2, which comes from Section 603, in which the scope of work is listed as a reconfiguration of space, the addition or elimination of any door or window, the reconfiguration or extension of any system, or the installation of additional equipment. The increase of the size structure places this into a stair structure, places this into level 2 alterations. Continuing on with that code review, Section 504 details where a fire escape can be placed, how the escape can be built, and what limitations and dimensions the escape must adhere to. In Section 504.5, opening protectives, doors, and windows located within 10 foot of the escape shall be protected by no less than a 3/4 burn rating. So that's where the interpretation came from, to protecting of the windows. And you'll see in Exhibit E, I've concluded those sections along, so there is graphic representation of exactly where those codes come from. A site visit was conducted with the chief building official, the assistant building official, and the fire chief, and determined that the openings were within the 10 foot of the escape, and it concluded that the openings needed to be protected under Section 504.5.
Did you just, excuse me for a minute, did you just say that an inspection was conducted with the fire marshal present?
It would have been our fire chief and not the fire marshal, sir.
Okay, thank you.
Yes, sir. So fire chief of the city of Rehoboth. If the Board of Adjustment determines that the building inspector misapplied the code, then the appeal may be granted and the stairs may be constructed without making alterations to the windows. However, if the building inspector's application of the code is correct, the Board of Appeals may not grant a variance or waiver of the code. Section 112.2, Limitations on Authority from 2018 IBC states, an application for appeal, shall be based on a claim that the true intent of this code or the rules legally adopted thereunder have been incorrectly interpreted, the provisions of the code do not fully apply, or an equally good or better form of construction is proposed. The board shall not have the authority to waive requirements of the building code. I think that's pretty important to note. The true intent of the code or the rules legally adopted thereunder have been incorrectly interpreted. This is a breakdown of that very section that I just read. The structure has been identified as a multifamily dwelling that has been converted to a condominium at the county level. The conversion supports the interpretation that this structure should be reviewed as a dwelling with more than 2 dwelling units. The structure falls under the requirements of a multifamily dwelling and must conform to the minimum requirements set forth by the International Code Council. The second charge, the provisions of the code do not fully apply. The code dictates that what can and cannot be built in relation to residential and commercial uses. The codes were established as the minimum requirements to protect life. As stated, the board shall not have the authority to waive requirements of this code. An equally good or better form of construction is proposed. To date, the application has not provided any proposal to address the requirements. Members of the building and licensing staff have offered several different methods to address the issue of protected means of egress, but no official documentation has been submitted recognizing either of these as protective measures. Such protective measures could include, but aren't limited to, of course, installation of a fire suppression system, abandonment of the windows within 10 foot of the egress, provide fire-rated blanketing over the existing stairs, or construct a fully enclosed fire-rated stair tower. The observation made by this office is to allow the structure to be built without the minimum protective equipment required by multiple codes will put lives in jeopardy when an emergency such as a fire occurs. The city may assume liability as the code requirements would not properly be enforced, and at least the minimum intent had not been met to ensure the safety of the dwelling inhabitants. The conclusion is that this appeal should be denied based on the following facts. One, the Office of the State Fire Marshal reviewed the project as a single-family residential building rather than a multi-family residential building. And two, the Memorandum of Understanding between the OSFM and the city provides that the more strict life safety code provisions would apply when the relative codes are in conflict. And three, the clear and unambiguous requirement of the international existing building code that windows located 10 foot of the escape, within 10 feet of the escape, shall be protected by less than 3/4 of an hour burn rating. I certainly can entertain any questions.
Well, I'll tell you what I'd like to do. First of all, I'd like to see if Mr. Mandalis has anything to add to that presentation at this point.
Sure, Mr. Chair, just very, very briefly, because I think there's a lot of documents here and a lot of different materials to look at, but what it really comes down to, we think, is less about what the fire marshal said and more about what the building official's responsibilities and duties are. And the building official's duties are to enforce the 2018 International Building Code. The fire marshal's duty is to enforce the life safety code. So I don't want the members of the board to become confused thinking that the fire marshal opined and never said the requirement of the 2018 International Building Code should or should not be imposed, because it's not his responsibility or his authority. That code is solely the authority of the building official to enforce. So even if the fire marshal had said, and he didn't in this case, but even if the fire marshal had said, I'm looking at these windows, I'm looking at this new set of stairwells, I don't think that you need a 3/4 hour fire rating on those windows. Even if he had said that, the building official still has the responsibility of looking to the International Building Code, which the fire marshal does not look to, and point to this section 504.5 that says when you're going to replace an existing fire escape, doors and windows within 10 feet of the fire escape stairways shall be protected with 3/4 hour opening protectives. So it really came down to a decision of the building official under a code that he's authorized to review and enforce. So the fire marshal is important because I think it's instructive sometimes to hear from the fire marshal on these things. And certainly if it was a life safety code issue, we'd be listening and looking hard at what the fire marshal has to say. But here, this is a building official code enforcement issue, not a fire code enforcement issue. Just want to make sure that was clear. And the reason these measures were triggered is because of the expansion of the stairs. Had the stairs not been expanded, my understanding is that we would have issued a building permit without any new requirements. A replacing kind would not have required anything new, but because the stairs are expanded here, it triggered these other requirements.
Okay, thank you. What I'm going to suggest we do then is allow Mr. Robertson to make his case, and then we'll, if we have questions for either party, we'll entertain them. All right, Mr. Robertson, would you please go forward?
Thank you, Mr. Capone. Just want to make sure everybody can hear me okay. We good? See lots of head nods. All right. Again, Vince Robertson with Parkowski, Girk, and Swayze, and I'm here on behalf of the appellant, which is the Cloisters condominium. This is an appeal, despite what the building officials said. It's actually, I think he cited the appeal provision of the building code. Actually, what gives you all authority is section 10256 of the Code of Rehoboth Beach. That's the code that incorporates by reference the building code, but your authority doesn't stem from the building code itself. It stems from the actual code of the city of Rehoboth Beach. And again, that's 10256 that allows you to hear the appeal. As was stated, this is an appeal of the building inspector's decision to deny a building permit to reconstruct existing rear stairs of the multifamily structure. And I thank Mr. Mendelis for making that clarifying statement that had these stairs been replaced or rebuilt in kind, we wouldn't be in front of you this afternoon. I want to put, one other thing. Jim Harrigan, who's on the call or on the video meeting, he is going to testify as a witness. He's the president of the Condominium Association. What I do, because I think it's a better means of presenting a case rather than doing a question and answer sort of examination of Mr. Harrigan, what I'm going to do is make the presentation, then bring him on at the end to just affirm. He'll be put under oath, I assume, by Mr. Townsend, and then affirm that what I have stated is accurate, or certainly make any changes to that. So he'll be coming on at the end. These are stairs. Somehow, though, this has gotten conflated into them being a fire escape. They're not a fire escape. They were never built as a fire escape. They're existing stairs off the rear of this building so that people can leave their units and get to their cars and go to the beach without dragging sand or whatever else all over the interior stairs. I think it's very interesting that we heard from Mr. Janis in the very beginning of his report. He called them a secondary means of access. Right. To me, if I was in court, I'd be filing for a summary judgment based on that statement, because if they're a secondary means of access, they don't trigger any portions of section 504-5 or whatever the section was that's attached as exhibit E to his report. These are just stairs. And along the way, they have been, like I said, conflated in something more than that. The fact of the matter is, as Mr. Mendelis said, if we had reconstructed them in kind, we'd have our building permit and we'd be on our way. The stairs were the subject, as I think everybody in Ms. Conacy, who wasn't on the board at the time, were the subject of the board's hearing back in July. It was July 27th. What I'd like to do, just for the record, because it describes the stairs, and I don't want to go through all that, is just to have the testimony of Jason Kania be incorporated, and I may be mispronouncing his name, but have that incorporated into the record of these proceedings. Mr. Capone, if we could do that, certainly referenced in the minutes, which are official records of the board.
Well, he's not here today.
That's true.
And we don't, and Ms. Conacy wasn't wasn't there. So I don't think we can just I may, and my recollection is imperfect. So without having a transcript of it at this time, I'm not inclined to just adopt his testimony and make a decision on it. Excuse me. All right. So if that's what you're asking, I'm not inclined to accept that right now. If you had a transcript that we could have been submitted, that would be fine. We did get a copy of the decision, so right. We are aware of what the decision was, and Ms. Conacy is aware of that as well.
Okay, no, that's fair enough. That's fair enough. Well, I will say it's reflected in the decision and the minutes of that hearing that the stairs are 40 plus years old, and they are currently wobbly and unsafe. I would point out that because of that, what we're dealing with is the city essentially preventing a dangerous situation from being corrected for multiple homeowners. And Mr. Harrigan's going to affirm that what the building and licensing department is requiring to essentially replace these stairs is going to cost about $100,000 or more to do when we talk about those doors and fire windows.
100,000 what?
Dollars.
Okay, because the owner is in Spain. I wanted to make sure we were talking about
right. What would lira maybe? No, it's dollars. Sorry, that's a guess on my part. But yeah, no, it's 100,000 United States dollars. Good clarification, Mr. Townsend. This is a 6-unit residential structure. There's been some question about that. Mr. Molina says, or actually Mr. Jana says, it was a single-family structure converted to multifamily, and there seems to be some implication that that was done surreptitiously. And I think that's relevant based on, that claim, based on the way this has been presented to you all by the Building and Licensing Department. I would point out that in 2018, the city approved a building permit for the sidings and the windows on this condominium. So they've known it's been a condominium at least since 2018. It was never a single family dwelling. We actually did some research on it, which I'm interested in Rehoboth Beach history. The building was originally built as a summer retreat for the Catholic nuns, which were the Sisters of St. Francis from the Archdiocese of Wilmington. And it was built about 1906. That church is, and actually is where the Star of the Sea condominium is now. And if you see old postcards or pictures of Rehoboth Beach, you'll see that there was that church complex that was built right on the boardwalk there. Eventually, they were getting battered by storms, and the church rebuilt away from the beachfront to its location between Laurel Street and Brooklyn, and that was in 1936. At around that time, the nuns' retreat was physically moved from the beachfront to its location on Hickman Street. Then the building continued to operate as a religious retreat and later as a rooming house until it was converted to condominiums in 1984. And the condominium declaration I looked up was recorded in 1984 when it was established. And I'll give you the sources for that, just so we have it for the records. It's actually the St. Edmund's Catholic Church History page, and that's at www.ste.org parish history. It's also the Sisters of the Third Order of St. Francis, 1855 to 1928, drafted by a member of the sisterhood. And that can be found at www.jstor.org/stable/44209-068. And that's also corroborated by a verbal history recounted by our former mayor, Sam Cooper, which his home backs up to the Cloister Condominiums lot. And as Mr. Harrigan will testify, he spoke with Mr. Cooper, and Mr. Cooper's ancestors were involved in moving the Cloisters building when it was still a nun retreat to its current location and operating the rooming house. And again, Mr. Harrigan will testify to that. It's existed that way for decades. It was never, not ever once, a single family dwelling, and it's not a recent conversion to condominium. I would add that this is also a recent issue that for whatever reason has been brought up now when we've applied for this building permit. It was never, to my knowledge, raised prior to the December 11, 2020 report from the Building and Licensing Office, and it was never mentioned in Mr. Molina's June 22 report, although, and that was prior to the July hearing, he describes the State Fire Marshal review process in his report from the prior hearing. The State Fire Marshal Office reviewed it as a multifamily condominium. And I know Mr. Janis referred to Exhibit C of his report, which is an email between, it looks like Dennett Pridgen and John Molina. Nowhere in it does it say in there, nowhere, that they reviewed it as a single family dwelling. If you read it, it says, I checked, and this is the top of that page, I checked the plan review programs I have access to and didn't find a record of conversion. However, it may have been done without a review by us. He's talking about a prior conversion. Nowhere in here does he say, we reviewed it as a single family dwelling, or if we had reviewed it as a condominium, it would have been different. At all times, they reviewed it as a condominium. I would add that's confirmed on the survey that was provided to the State Fire Marshal, which is in the city's file. It's apparent from the photographs provided to the State Fire Marshal, which are the same as what you saw attached to the Building and Licensing report. It's apparent from the turnstone plans that the State Fire Marshal's office reviewed and which the Building and Licensing Office has. And more importantly, the cover page of the State Fire Marshal Office report states that this is a condominium. I don't know where we're getting that it is a single family dwelling, or that if it was somehow reviewed improperly by the State Fire Marshal, or it wasn't disclosed at a condominium. It's a condominium. It's a multifamily structure. It's been that way since 1906. I don't know what they mean about it was done somehow by approval of the county. That's just not how condominiums work. It's taxed by the city of Rehoboth Beach as individual condominium units. It's been that way since 1984. It's billed by the city of Rehoboth Beach for water and sewer and all that stuff as a condominium. I don't know where any of that's coming from, and I would ask that you disregard that statement. Mr. Capone mentioned that the project was subject of the board's decision, and I'm glad that you all have a copy of that decision, had an opportunity to review the decision in minutes. I just want to highlight some of the things that you all found in your written decision. Number 4 of your written decision contained the finding, the structure, and this is in quotes, quote, the structure sought to be replaced was originally constructed in 1984 using pressure-treated wood. It is described as wobbly, having outlived the typical lifespan of its components. Number 3, the enlargement of the proposed staircase is represented to be the minimum necessary to comply with the current fire safety regulations. Number 8, the proposed replacement of the staircase structure promises to enhance the safety thereof in various respects by relocating the ground level access point away from the path of vehicular traffic, by replacing wooden components installed in 1984, and by utilizing more secure fastener mechanism, etc. Number 11, and this is from the decision on the variance at that time, and that's item D. The variance was approved unanimously by the board with specific findings, including that, quote, the proposed improvements offer an enhancement of various safety considerations, close quote, and 11E states, quote, the proposed improvements are consistent with the character of the area as the staircase is simply being replaced rather than added to an existing structure, close quote. I would add, too, that from the minutes of that meeting, Mr. Cassell voted for. He stated they are adding approximately 76 square feet. It is for safety, and they are not asking for anything more than what the state fire marshal was requiring. These plans went through the standard building permit application process, including the Delaware State Fire Marshal. Again, they reviewed it as a multifamily structure. They saw the plans, they saw the photographs. Yet, the building inspector, for some reason, contrary to what we just heard at the beginning of this hearing, applied section 504 fire escapes and stated that because it's a fire escape, even though he just said it wasn't, 504 provides that doors and windows within 10 feet of fire escape stairways shall be protected with 3/4 hour opening protectives. There's no basis for that in what's being sought. This is just the replacement of the existing steps as this board specifically found in its August decision. And I would say, that this followed a specific planning meeting with Mr. Janis. Mr. Kania was, and he testified to this at the prior hearing, he was instructed to develop the plans, meet with the state fire marshal's office, obtain the zoning variance, and then get the building permit. We heard today that somehow or another they just went off on a whim and got a variance without a building permit. You heard, with the exception of Ms. Conacy, that's not what they were instructed to do. They were specifically following a pre-construction meeting, which is what you want every builder and contractor and property owner to do in the city. They met with the Office of Building and Licensing, asked, what do you want us to do? And they said, develop plans, meet with the state fire marshal's office, obtain any zoning variances, and then get the building permit. They developed the plans, they met with the state fire marshal's office, they obtained the zoning variance from you all, they applied for the building permit, and the rules completely changed and they were denied that building permit. I would point out, and it's interesting to me that Mr. Molina didn't, or Mr. Canis didn't supply this. In that email chain, there was an earlier email, and I'm going to quote it to you all, dated May 26, from Mr. Kania to the building officials, where he confirmed this. He states, I was told what would be necessary would be a review with state fire marshal, and whatever the fire marshal wrote was needed, should be incorporated into the building plans and resubmitted. I was also told that if the fire marshal provided an approval, that we could then go ahead and submit our variance application, and if approved, that no further requirements or review would be needed by the city of Rehoboth, and we would be able to be issued a building permit without further delay. So after the Cloisters went through that process and followed the instructions given by the city, including a variance from you all, then we suddenly got stuck with the denial of our building permit. I think this board, for the members of the board that were on back in July, I think even you recognized that the last minute change in requirements was questionable and frankly patently unfair. If Mr. Janis's initial instructions were correct, and following them complies with the code and does not create a safety issue. First, it's undisputed that the Cloisters were rebuilding the stairs in kind, as we heard from Mr. Mendelis. They could do so without one of these new requirements, not any of it, not new windows, not new fire doors, not anything. They rebuilt it in kind. We're rolling. We've got a building permit. That's what the original plans were for, and those plans were submitted to the State Fire Marshal's office and reviewed for that multifamily structure. The State Fire Marshal approved them as an in-kind replacement, but simply added the requirement that they be widened. Let me make that clear. That was not the applicant or the Cloisters or the builder's request to widen these stairs or make them anything other than what was there previously. The State Fire Marshal, if you read that report, asked them to the treads and risers to be widened so that they were a little bit bigger and a little bit safer. Again, that was not at the request of our client. And so, but for that State Fire Marshal requirement, this is an in-kind reconstruction of the existing stairs. And I would say that widening the stairs does not increase in any way fire safety risk associated with the stairs. Here's the logic of this. If we widen them a little bit, so we could build them right now the exact same way they are. Like I said, get the building permit. How is there an increased safety risk at all that triggers all these new requirements if all we're doing is widening them up by about 6 inches based on what the State Fire Marshal had? That defies common sense and logic. I mean, these are the same stairs, a little bit safer because of the State Fire Marshal, and now we got to comply with all these new requirements based on the claim that they're a fire escape, which we just heard that they're not. I want to go through a little bit the building code because we heard about that from Mr. Janis, and what we're under is the International Existing Building Code of 2018, Section 502.1. There's grandfathering provisions in here. Section 502.1 of the code states that alterations to the existing building or structure shall be made to ensure that the existing building or structure, together with the addition, are not less complying with the provisions of the International Building Code than the existing structure or building was prior to the addition. So that's a grandfathering requirement. Basically, if you keep it at least the same as it was, then you should be able to proceed under the International Existing Building Code. We're actually making them a little bit safer because we're complying with what the State Fire Marshal said. It was definitely not less complying, it's better. Section 301.3 talks about alteration, addition, or change of occupancy. It says that if you do that, that there's an exception. Alterations complying with the laws in existence at the time the building or the affected portion of the building was built shall be considered in compliance with the provisions of this code. So again, that goes back to what we're saying. If they're rebuilt in kind, you can rebuild them exactly as they were, and it doesn't trigger new building code requirements. So, we're not asking for a variance from the building code. We're just asking for the building code to be applied correctly to allow these stairs to be rebuilt. So with that in mind, what I want to do is go through the conclusion of Mr. Molina's report before I get to Mr. Harrigan to confirm everything. The observation at page 3 of his report, he states that the city may somehow assume liability if the code requirements are not properly enforced. And I would say there's a double negative in this sentence, but the code requirements are not properly being enforced. As we set out above, this type of alteration is grandfathered under the building code, and we heard from the city's attorney that they can be rebuilt the way they were. I would say also, we've got a bunch of lawyers on this call, that if you're modifying what the State Fire Marshal says and creating your own ad hoc fire issues, you're potentially creating worse liability for the city. I want to quote to you what Title 16, Section 6612F of the Code, the Delaware Code states. The State Fire Marshal or the Marshal's deputy or deputies shall enforce all laws and ordinances of this state and the several counties, cities, and political subdivisions thereof, having to do with the means and adequacy of exit in case of fire from buildings and all other places in which numbers of persons work, live, or congregate from time to time for any purpose, except buildings used wholly as dwelling houses containing no more than 2 families. So it excludes single-family structures, which we heard this was a condominium. Section 6612L1 confirms that the state fire marshal or the marshal's designee shall review all plans and specifications, with the exception of those political subdivisions having exclusive jurisdiction over subdivision C of this section prior to actual construction. And C is a carve out for cities like presumably Wilmington, I don't know, maybe Dover, that have established their own fire marshal office. Rehoboth does not have its own fire marshal office. I know we heard that the fire chief was out at the site, and I respect the fire chief of the Rehoboth Beach Volunteer Fire Company, but he doesn't have any authority over building code, and he certainly doesn't supersede what the Delaware State Fire Marshal says with regard to building construction. So what we have here is an ad hoc determination of fire requirements that is intended to supersede the statutory role of the Delaware State Fire Marshal's office. If that occurs and the city missed something on a building because of the city's error, that would create liability. In other words, if they think they're better or have the ability to supersede the Delaware State Fire Marshal's office, which seems to be the case here, and they put themselves in the shoes of the State Fire Marshal's office, which they seem to be doing here, and they miss something, that creates liability for the city. Instead, the city should leave fire safety reviews to the legally designated authority for that review. Then it has a defense to any claim of liability since it relied on the statutory review instead of just doing an ad hoc fire safety review, like apparently the city's trying to do. As soon as the city steps into that arena, it takes on liability. There's reasons for denial in Mr. Molina's report. The first one is, he says, quote, the Office of State Fire Marshal reviewed the project as a single-family residential building rather than a multifamily residential dwelling. That's just not true. And they don't state that anywhere in that email that the city has relied upon. It does not state that they reviewed it as a single-family dwelling. Their own report calls it a condominium. They were asked the question of maybe when a conversion occurred. They said they didn't know when a conversion occurred, but that doesn't say they reviewed it as a single-family dwelling. You will not find that anywhere in the record with regard to conversations between the city and the state fire marshal. And in fact, as I said, their own report calls it a condo. It's been that way. It's never been a single-family residence. It's been that way since, like I said, 1906. The second item is the memorandum of understanding between, this is quoting from Mr. Molina's report, the memorandum of understanding between the Office of State Fire Marshal and the city provides that the more strict life safety code provisions would apply when the relevant codes are in conflict. First of all, I don't think there's any conflict. The building official stated that these are a secondary means of egress. So if that's the case, that throws out all that fire marshal stuff. The other thing is, if you look at that Exhibit C to the State Fire Marshal's report, Mr. Pridgeon, in his reply to Dom, this is the July 29 email, he says that all of the items were in accordance with the life safety code requirements, and the submittal was approved as accessed as a minimal impact. So, you know, there's not any more strict life safety code provisions. We've got the state fire marshal's own words saying that it complied with the life safety code requirements. So there's no conflict there. The second thing is, you know, you get back into the strict life safety code requirements. I go back to what I keep coming to when I was analyzing this. How is there a life safety code issue if the city would allow this structure to be rebuilt in kind without triggering those expensive improvements that Mr. Molina is claiming should be done? You know, again, we could just rebuild this. We actually, you know, did what we're supposed to do, went to the state fire marshal. They said improve it a little bit, and we did so, making it safe. I suppose if the state fire marshal said, yeah, we're fine with it the way it is, like I said, we'd be building a building permit. If it's safe as is, how is it not safe, completely rebuilt with wider stairs? Ask yourselves this, what is the trigger for the more life safety code provisions that are claimed to apply in this case? There's just no common sense or logic to that. And as I said, there's no conflict in the codes as cited above, that I mentioned before with regard to the existing building code requirement. The code allows an alteration such as this to an existing structure. And then the final one is the clear and unambiguous, is the final conclusion of Mr. Molina, the clear and unambiguous requirement of the International Building Code that windows located within 10 feet of the escape shall be protected by shall be protected by not less than a 3/4 acre hour burn rating. Again, that's based on the claim that it's a fire escape when it's just exterior stairs. That's not a clear and unambiguous requirement of the code. The Office of State Fire Marshal did not require it. And as I said, the International Building Code for existing structures specifically states that structures such as this are grandfathered and can be rebuilt without triggering the current IBC requirements. So, I mean, I don't want to try to make calculus out of common sense here, but when we've got the city saying you could rebuild these, we went to the State Fire Marshal and they said, well, you can rebuild them. Let's make them a little bit better. We go back to the city after following the process that they outlined, and now the city says we're not going to issue a building permit. That's not the way this should operate. Somehow or another, something got messed up in the process here, and we should be well underway with a building permit, eliminating these wobbly stairs, getting them rebuilt to what the State Fire Marshal has said, again, based on the State Fire Marshal's authority in the Delaware Code, and why that building permit was denied, particularly in light of what we just heard, now that they're actually not a fire escape, but a secondary means of egress, to me just defies logic under all these circumstances. So with that, what I'd like to do is I'd like to call Mr. Harrigan back on, and if he could be sworn in by Mr. Townsend, just to introduce himself and then confirm what I've said and anything to add to it.
Very well.
Hi, Mr. Harrigan.
Hello, everyone. Sorry, I got a little background noise here. Can you hear me okay?
Yeah, Mr. Harrigan, could you give us an address for the record?
My address is Calle Serrano. I'll spell it out, C-A-L-L-E. The next word is Serrano, S-E-R-R-A-N-O. Number 42, Madrid, Spain, zip code 28001.
Mr. Harrigan, do you solemnly swear or affirm that the factual representations made by Mr. Robertson on your behalf are true and correct to the best of your knowledge?
Yes, I do.
Thank you, Mr. Townsend. Mr. Harrigan, thanks for appearing today all the way from Madrid, Spain. As I said, just right before we got on it, this is the first ever public hearing that I have done internationally. So this is a new one for me and maybe everyone else on this meeting this afternoon. So thank you very much for taking time out of your busy evening, I guess, at this point in Spain. Just one thing before I get to you confirming, you are the president of the condominium association?
That's correct.
Okay. And if you could, just since you are in Spain, if you could just describe how actively you are involved in the management and the operations of that condominium. I don't want folks to think that because you're in Spain, you're, absent from the property or not involved in it.
No, so we have 3 officers, president, vice president, and the treasurer. And we communicate, quite regularly, especially with regard to number one, improvements. All of the residents, owners, I should say, because nobody was there, the 6 owners, we communicate quite regularly, coming and going, because the building, as you laid out pretty quickly.
I can't hear him.
Yeah, no, it looks like he froze up.
That,
Mr. Harrigan? Mr. Harrigan, just real quick, we lost you for a second. We had a screen freeze. So if you could go back to where you started to say there's 3 members of the board and you started to talk about particularly, and then I think we lost you at that stage.
So we communicate quite regularly on items regarding maintenance and comings and goings. I was saying that we have problems sometimes in the winter with frozen pipes, and so we have a process of turning the water on and off. So as different owners come in during the winter, there's communication about that. We've had some conversations about interface with our neighbors. And so we are regularly engaged, the three of us, as well as the other owners. We're a small group and coordinate quite a bit. I will, the financial part, the treasurer takes care of paying the bills. I don't get involved in that too much. We have our twice-a-year meetings to review the budget, review the expenses, look at our reserves, and prioritizing repairs and maintenance. This particular job has been on our list for quite a while, and so we look forward to trying to move this forward at this time.
Thank you. And then you've heard everything that I stated to the board this afternoon. Again, maybe it's this evening where you are, but do you agree or affirm all the statements that I made to the Board of Adjustment in my presentation?
I do. Everything's accurate and aligns with my knowledge and review of the material as well as the time I've been involved in the condo since 2016 and our attempts to try and get the back stair replaced. Yes, sir, all correct.
Mr. Harrigan, if I could interrupt 1 second, I had asked you to confirm the factual representations or the accuracy of those representations made by your attorney. Could I also ask you to affirm that the testimony given in this proceeding is the truth, the whole truth, and nothing but the truth?
Yes, it is.
Thank you.
Just because you bring it, I will editorialize a little bit on the $100,000. It wasn't $100,000 just for the windows. It was that the total job would increase based on our estimates from the builder from approximately 40 or 50,000 for the siding and stairway. And if we had to use the fire protective windows, it would put us over 100,000. So that's where that number came from, just to be clear. It wasn't 100,000 just for windows. But still,
thank you, Mr. Harrigan.
Yeah.
And I apologize for that, for misstating that if I did. I don't have any other questions for Mr. Harrigan unless there's anything you'd like to add. It sounds like you expanded upon, some of the things and clarified them. Is there anything you would like to add for the board's benefit this afternoon?
No, just that. I think Vince laid out very clearly the way we think the code was misapplied, and just as don't want to whine in front of the board here, but just as a group of owners, trying to get this work done, it can be a challenge, and so we just look forward to a fair hearing and a fair decision. That's all I have to say. Thanks.
Thank you, Mr. Harrigan. Based on that, I'll just conclude by stating I went through those conclusions and the observation of Mr. Molina's report. I think each one of those has been and can be refuted. We're not asking for any special treatment. We're asking for a fair application of the code. And this is one of those, again, like just to sum up, when I was first presented with this, it's kind of one of those moments where you're like, well, let me get this straight. You could rebuild it exactly as it is. You went to the state, and you got the variance to do that. You went to the state fire marshal. They said, let's make it a little bit better. And now you can't get a building permit. Again, there's just, we have to operate as a city and as property owners, as builders and contractors. We've got to follow the code, but we've also got to have logic and common sense in how we apply it. And if you could rebuild that, and the only change you're making is at the state fire marshal's behest, why isn't there a building permit that's issued in this case? So with that, I'll wrap up and certainly make ourselves available. And Mr. Harrigan's going to stay on if we have any questions that we can answer. Thank you, Mr. Capone, and members of the board for allowing us to present today.
All right. So at this section now of the hearing now, we're going to ask for questions from members of the board, and then we will allow any public participation in the hearing. So Barry, I've seen you raise your hand, so if any questions,
Yeah. The question I'm left looking at Exhibit C. Clearly, the fire marshal reviewed this as existing deck on the rear of a house, residential use. But yet, Mr. Robertson is correct. The report comes back, says condo. So we don't see anywhere in our exhibits what the city fire chief, I'm assuming he submitted the application to the fire marshal. We don't see that. So we don't see...
Mr. Brandt, just real quick, that's not how it works. The applicant or the applicant's contractor submits it to the state fire marshal office.
Okay, so we don't see that as an exhibit. So we don't know what Dennett Pridgen is reviewing. It looks like he's thinking this is a house. But yet the report comes back in support of Mr. Robertson saying, yeah, it's a condo. I clearly believe there's a breakdown somewhere in exhibits that we are not, we are not seeing. It goes in as one thing, comes back out as, you're approved, but I'm left to believe that the fire marshal is reading this as a house. But if the builder submitted photos, again, I'm speculating because I don't know what was submitted in here. So it's very, very confusing. What did the fire marshal actually look at to come back and say, you're good to go? So that's one question. Is there a reason why we don't have that exhibit?
Well, I can tell you, Mr. Brandt, that the exhibit that's relevant is the one that's the fire marshal's approval, which states on the, it doesn't matter what happened up to that point,
but
it's what came out of that process.
That's
and
right.
that is that it's the Cloister Condo Association.
And I'm in agreement with you there, but the email from the fire marshal says, I looked at this as a house, which makes
Where does it?
Exhibit C, the email from Dennett Pridgen back to Dom.
Which email are you looking at? Because I don't see where it says that as a house.
Exhibit C, page 1, the bottom of the page. He says, Dom, I reviewed this as replacing an existing deck on rear of house. And I'm wondering whether the fire marshal got confused. And, if the builder submitted photos, or did he not? Again, I don't know what was submitted to the fire marshal from the builder as an exhibit. That would help. That would have really helped clarify whether a true mistake was made at the fire marshal office.
Well, I'll go back to what we have, which is in the record, and that is the state fire marshal's permit. We can talk about emails all we want. The legal document is that permit, which talks about it being a condominium.
Right.
And so, and I'll add to it that the photographs that are Exhibit A to the building officials report are what the building official, and that's what's there. That's what they reviewed. That's what was reviewed by the state fire marshal office. But here's the important thing. Let's not get lost on red herrings here. We heard from the city, single family dwelling, multifamily dwelling, it does not matter. If you had rebuilt those stairs exactly the way they are now, we're fine.
And that's why
there was no distinction in what we heard from Mr. Mandelis.
Okay.
And that's what we're doing, but for the state fire marshal saying that the stair treads have to be wider, that structure has to be wider. I don't even know that at this point it matters whether they reviewed it. If, we're going to apply common sense to this, which I think we always should in every decision we make. But we have the permit that says it's a condo. So
right. And that's okay. I'm good, Jerry. And thank you.
Anybody else have any other questions from the board? Jan?
What's
this is the court reporter. Mr. Harrigan, could you please mute your audio again? We're hearing your background noise. Thank you.
What's the occupancy for each of the condos?
Ms. Connessy, it would apply just to whatever the occupancy.
It doesn't matter, Vince. I just asked a question. What was the occupancy?
There's 6 condos.
Well, I know it's 6 condos, but what's the occupancy Are they all, what's the occupancy for each condo? There should be some kind of occupancy rulings for each condo.
Well, that would go back to the definitions in the zoning code. It's just like every other house in Rehoboth Beach.
Well, I understand that, Vince, but if it has 3 bedrooms and a sleep sofa in the living room, you have 3 bedrooms, you have 2 people in a bedroom, are there 8? I have no idea the size of it. There's nothing that indicates.
Having sold units in there before, I believe they're all 2-bedroom units,
Okay, so the occupancy is probably 6 people.
6 people.
So 6 times 6, there could be 36 people in there at any one time.
It's kind of see so Mr. Molina's relied on the building code. The building code doesn't talk about occupancy. The zoning code doesn't talk about.
I just asked a question. That's all.
Okay, all right. I'll object to the relevancy of it, but that's fine. No, it's a good question just to understand the nature of the building.
Jane, any other questions?
Go ahead, Randy.
So Randy, why don't you go ahead?
Okay, I actually have one for Mr. Janis. Can you just confirm that they would be able to get a building permit if they reconstructed the stairs exactly as they are without widening them per suggestion of the fire marshal?
Thank you, Mr. Mason. The answer to that is they would be allowed to replace up to 50% of that stair structure. So the 50% rule would come into application here. Originally submitted, they wanted to increase the size of it. So you can't allow that to go through with increasing the size of it, hence the initial trip to the variance for the variance request. Upon replacement of the structure, once they hit 50% of the structural components of the stairs, they would be required to bring the entire stair structure up to code.
Mr. Townsend, can we put Mr. Janis under oath? Because that statement is incorrect. We went with the plans. The only reason that they were expanded was because of the state fire marshal's requirements after the initial meeting with Mr. Janis. He's making it sound as though on the initial meeting they were expanded, and that's just simply not the case.
I don't have any objection to putting him under oath. We don't typically do that, but I think there probably is some relevance to the initial discussions that were had prior to anything being submitted to the fire marshal. So if you'd like him to testify under oath to that, I don't take issue with it.
Okay, so why don't we do this? If you, Glenn, if you think that he needs to testify under oath, then we'll put him under oath. And if you want to ask him some questions, then we'll allow that to happen.
Well, it's certainly a deviation from practice. I would not like to see it become, what we do all the time as city employee. I'd like to not have to always put them under oath. For this one instance, Mr. Robertson's asked for it. I don't have any problem with it. So unless Mr. Janis has significant heartburn with it, I don't have any problem putting him under oath.
I guess my only issue would be that I was not, while present, I was not the initial building inspector to make the interpretation. I don't know if that plays a cause in it.
It does. Was Mr. Molina present?
He is.
Yes.
And is he prepared to testify?
Yes, I am.
Okay.
Let me begin by.
Mr. Molina,
Yes.
do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes, I affirm.
Before Mr. Molina begins, could I ask some questions of Mr. Janis? Because that's sort of where this was coming from.
Is it?
And I'll be short.
Something that he was there for that he can testify about directly, do you think?
Yes.
All right, go ahead.
So, Mr. Janis, isn't it true that you were first present with Mr. Kania when he came in to meet with you to review the plans for the replacement of those secondary means of access stairs? Is that true?
To the best of my knowledge, yes, sir, it is.
Okay. And at that point, there was no plan to expand the stairs. Is that true?
That is not my recollection. Excuse me. What originally was applied for, and if memory serves me correct again, was that the original proposal to expand these decks and staircases, it was stated as for the ability for the inhabitants to put barbecues and grills on those sections of stairs.
I got to tell you something. This is, to the best of my recollection, this is contrary to what we heard at the last hearing for the variance. That we were told, and there was no indication from the city that that was part of the reason for the stairs. We were told it was just a means of egress for the house. There was not going to be chairs or socializing on those decks. How about the rest of you board members? You guys align? Yeah. Okay.
I'm in line with Jerry.
Yeah.
It was never mentioned.
Then,
I
Mr.
believe-
Janis, oh, I'm sorry.
I believe there was a concern that these areas could become areas that would be occupied if they were sufficiently enlarged, and that was not the contention of anyone in the prior proceeding.
And then, Mr. Janis, isn't it true that you told the applicant or the contractor to go meet with the state fire marshal to get their approval?
That's absolutely correct, as this is a six-family dwelling unit, absolutely. So in the city of Rehoboth, all commercial properties require state fire marshal.
All right. So is it true then, to the best of your knowledge, did the fire marshal know that we were dealing with a 6-dwelling unit here, 6-dwelling property?
I do have a recent email that did not get submitted to me in time to be placed on the agenda. That reaffirms Mr. Pridgeon's position. The plans only showed the stairs from the dwelling exterior wall out. The application for plan review states replacing existing deck on rear of house. The use is described as residential use.
But are you telling me that he was clueless about this being a 6-unit condominium?
It is my belief that he was not told this was a multifamily application.
So you're telling me you didn't have a conversation with him in which the fact that it was a 6-bedroom, a 6-condo unit was mentioned?
Not prior to the variance request and not up to this meeting.
Okay, so you're telling me then that you've never discussed with him the fact that this was a 6-unit condominium?
I personally did not know, sir.
How about you, Mr. Molina?
I had, by the way, happy holidays to everyone.
Thank you. Now, what's the answer?
Let me give you
Let's just go. Did you ever discuss with the fire marshal's office that this was a 6-unit condominium?
Yes, I did.
Okay, when?
When, as early as when the building permit, not for the initial variance request, for the enlargement, when the building permit was submitted.
All right, so when the fire inspector issues his report, you've already talked to him and he's known that this is a 6-unit condominium.
Right.
All right. I think that settles that.
Okay.
May I ask Mr. Molina a question?
Go ahead.
Did you ever discuss, Mr. Molina, with the applicant, the idea of expanding the stairs for grills, chairs, any of those sorts of things?
Well, there was a concern about the potential use. And from the variance, I did not oppose the variance, the enlarging of the stairs, because you're improving a means of egress. I do have concern for if they will be using the deck portion for any other activity. And at the same time, I mentioned to him that even before the variance request, that he will require to meet other requirements of the building code.
Right. I remember you mentioning that during the last Board of Adjustment hearing as well. But when you initially met with them, did they suggest that they would like to expand the decking areas for reasons other than purely for egress?
Well, what was presented to me was basically they wanted to enlarge and address some safety issues.
Okay.
All right. So, okay, Jan, you have a question?
I just want a clarification, I guess. I thought that what Vince was saying was that the fire marshal said the stair treads needed to be wider or something. I didn't take that to mean that the landings, what I would call a landing, what you're calling a deck, were going to be made bigger also. Just the treads, the width of the treads and the depth of the treads going up and down the stairs. Is that,
Well,
did I misinterpret that?
Correct. The structure was enlarged from, I believe, 76 square feet to 114 square feet.
But that also included the decking?
Well, yes.
Oh, okay.
Ms.
Thank
Connolly, I can explain. So
Yeah.
the fire marshal, let me get up here, we can see my hands. Wanted the stairs, like the treads to be this way wider as you're
Right.
going up.
Right.
And then also 6 inches this way wider,
Right.
which would
That's what I understood, but I didn't understand anything about decking being bigger.
no, there's no decking. And we can bring Mr. Harrigan back on. As he stated, as I asked that question of him as well, he explained that, there's landings, because you go
Well,
up
I
the
would,
stairs.
that's
Yeah.
what I'll use landings. Yeah.
Yeah, and as he said, there was never any room from day one to put grills or anything on any of those landings. It's essentially, and maybe we need to bring him back on, but just, as he said, perhaps you could stick a potted plant in the corner, but that's about it. It's just the landings for
So
the
the
stairs.
landings would remain the exact same size as they are.
Well, they'd be widened a little bit, because if the stairs are widened by 6 inches, the landings would be widened by 6 inches. That's the idea.
Barry, you're the hand up.
Yeah, Jerry, I don't know if I'm allowed to ask this, but to the president.
Yes, you are.
Okay, to the president of the Homeowners Association, how many stairwells exist in this building, including the rear secondary? Is it 2 or 3? I'm assuming there's a front. And I'm
So there's a front door to the building and an interior stair, one straight up. Well, let me put my camera on so I can use my gesturing. Go straight up with the 6 doors, right? Starting from the ground level, second level, third level.
Okay.
And then in the back, each unit has what I would call a back door. And then the 2 ground floor units, of course, just exit out to the back. And then 2 and 3 are serviced by these stairs, right? And as Vince was saying, that's the landings serve as a turn point. Stair goes up, you turn, go up the other side, right? And the landings. And as Vince said, because the width of the stairway was expanded, my understanding, I wasn't with the fire marshal, but in all of our discussions internally, it had to do with, in case that emergency personnel had to go to the building with all of their equipment they carry, the fire marshal wanted it. So it was wider. So that means the landings where they extend from the building would be somewhat wider, but they're no deeper. There's no bigger turnaround area. There's no place for chairs, barbecues, or anything like that.
So a total of 2, not 3. There's no interior rear stairwell.
Negative, that's correct.
Okay, thank you.
May I follow up on that?
Sure.
I think it's an important question that Mr. Brandt asked, because there was some discussion about whether this is a fire escape, not a fire escape. We know that the Life Safety Code requires a second means of egress. This is a second means of egress, but it's also required for fire safety purposes. So each of the fire safety purposes egresses that are required in the safety code require this sort of rating, this fire rating. So I want to be careful not to get confused with what you're being asked to do here, because, and Vince was good and said that this is not a variance, because and it's not a variance. Whether it's 6 inches or 6 feet, that's not relevant to your consideration today, just like it wasn't relevant to the building official's decision making. The building official, when the code says if there's an expansion, here are the requirements. In this instance, there's an expansion, and he doesn't have the building official does not have the luxury of saying, I'm going to look the other way on this one. Yes, it isn't a huge expansion, but it's an expansion that triggers these other requirements. And that is really what this board should be focused on, is, was there a proper interpretation of the code? Not any question about how big is the expansion. It really comes down to, did he interpret the code correctly?
All right, Barry.
One final question, sorry. I read the memorandum of understanding between the city and the state fire marshal. If we were to approve this to go forward, there is still a chance that the cloisters would not get an occupancy. In other words, you could spend all this money, finish the staircase replacement, and still not get an occupancy. So there's like one more hurdle that, I'm wondering what, whether do it right and then, get your occupancy, because I'm afraid you may be back here again.
I'd reply to that and that, I understand your concern, but the state fire marshal's office, they've reviewed it and signed off on it. So with the expansions that they have, it's not like they get another bite out of the apple after the building permit's issued.
Okay, thank you.
I would like to reply to just what Mr. Mandela said. And I hear what he's saying, but I want to refer you back to those sections of the existing building code that deal with grandfathering of existing structures. And it talks about alterations to existing buildings or structures made to ensure that the building or structure together with the addition are not less complying with the provisions of the IBC than the existing building or structure was prior to the addition. So, I hear what he's saying, but at the same time, we're not less than it was. We're actually more in compliance because we're dealing with what the fire marshals told us. So I just wanted to sort of bring that back.
I have a couple of questions, and I'm going to address them to Mr. Mandalis, and he may want to involve the building inspectors on that. Is there any legal distinction between an exterior stairway or means of egress and a fire escape? And if so, what is the distinction?
I think there is, and I'll ask the building official to add more if he thinks it's necessary. So a secondary means of egress, an outdoor secondary means of egress, my understanding, and the building officials again, if it's your secondary means of egress under today's life safety code, it has to be enclosed. You wouldn't be allowed to build the sort of stairs that you see on this structure today as a secondary means of egress, an exterior stairwell that's not enclosed. So if it's purely just an exterior stairwell, like to Mr. Brandt's point, if it's a third means of egress, you could build this sort of a structure today. But if it's only a secondary means of egress and it's going to be needed for those life safety reasons under the life safety code, you couldn't build this structure. So a fire egress or a fire escape is different than an exterior set of stairs in that it's a requirement for life safety reasons. You could have an exterior set of stairs that's a third set of stairs that's not a requirement. But
so are you telling me that because it's a secondary set of form of egress, it is a fire escape?
Yes, and building officials, can you weigh in on that?
Certainly. So with the changing of the code, fire escapes have gone by the wayside. Now it's all paths of egress and means of egress. So fire escapes are not permitted anymore. They're actually paths of egress. All paths of egress need to be protected.
Okay, so that's your answer to that question. So then let me ask you this question. If they suppose that these folks wanted to make improvements to the interior stairway, the existing interior stairway, they wanted to put new rails or change the surface of each step, would that trigger the same provision that we're dealing with today?
No,
Why not?
no, because all the improvements will be interior. All the improvements that will be planned will be interior. We're talking about a fire escape.
But John, let me stop you for a moment there. You're going to the exterior. May I weigh in?
You may.
What I wanted to mention, Dom, though, if there were interior life safety requirements triggered by the expansion of the interior staircase that's also required under the life safety code, that would trigger additional interior life safety fire requirements. Correct?
Yes, it will. Yes, it will.
Yeah, let me add, if there were structural changes to these stairs, we would have to force the 2-hour rating and the protection of these stairs.
Who's speaking right now? I can't.
Matt, sorry. You could simply go in, replace treads, handrails, that's cosmetic stuff. But if you were to tear into the walls and start doing enlargement, it would have to be a protected staircase at that point.
Okay, so that's that question. Now, if we could turn our attention to Exhibit A, which was the series of photographs that we have. Are we talking about the windows that are depicted on the rear wall would have to be replaced?
That is correct.
Yeah.
Okay. How about the windows on the side wall?
They are not within 10 feet, so they would not be required to do so.
And how about those all the doors on the rear side of the building would have to be replaced?
The doors would need to be fire protected as well. Yes, sir.
Is there anything that would need to be replaced that is not depicted on these photographs? Is there anything inside that we should know about?
Not at this point, not for this type of application.
All right, and the city is taking the position that you're disagreeing with Mr. Robertson, and you're saying that if they were to tear down this existing structure and replace it in exactly the same size and location, they would still need, this would still implicate the need for the fire rated windows. Is that what you're saying?
We have the 50% rule that would apply at that point. If structural modifications were done that equivalent 50% or more, then the entire structure would need to be brought up to code. Yes, sir.
Mr. Capone, can I ask you a question and follow up to that?
Sure.
Mr. Janis, when did you meet with Mr. Kania, the initial meeting that you had with him?
I do not remember a specific date. I can certainly check my calendar and go back in time.
But you do remember meeting with him, is that correct?
I certainly did. Yes, sir.
Isn't it true during that meeting that you didn't say anything to him about having to meet fire code if they rebuilt that stair structure exactly as it is?
He presented that project to us as an enlargement from the original size. So we instantly took the position you're going to need a variance for this because of the enlargement.
I see what you're saying.
Who describe for me the enlargement that he presented?
He came in with larger stairs than what were existing, so that constitutes an enlargement, which this office does not have the authority to grant in the case of existing non-conforming. And in this specific case, it was lot coverage.
All right. I have a question. Go ahead. Go ahead.
So, Mr. Janis, what you're stating to me is that the testimony of Mr. Kania during the July 27th, 2020 meeting, that he met with you, went over plans that were to replace the stairs in kind, that he went to the state fire marshal at your suggestion, that the state fire marshal changed the plans to expand them based on what we heard Mr. Harrigan testify to. They came back, they went to the Board of Adjustment like you had stated, and then the building permit was declined. You're stating that that testimony, this board's finding, the email from Mr. Kania, and Mr. Harrigan's testimony is all incorrect. Is that your testimony this afternoon?
I know what I encountered during this. Unfortunately, I was not part of the entire process for this particular one, but I know what was presented before me, and hence why number one, the requirement of the city of Rehoboth Beach and all commercial properties is to go to the office of the state fire marshal for at least a handshake, if you will, or an agreement that this construction does not meet any of the requirements for the fire marshal.
Okay.
And number two, that the enlargement of the structure automatically triggers the variance request.
Isn't it true, Mr. Janis, that during that meeting? No, Mr. Capone, this is important.
Hold on a second, Ms. Robinson. We've given you some leeway, both sides, to ask questions. We don't typically do that.
But Mr. Capone, here's the issue I have is that my folks met with Mr. Janis. He actually, and I'm going to ask Mr. Janis this. Mr. Janis, isn't it true that during that meeting, you went out and asked Mr. Molina's opinion whether the plans were fine and came back and they were fine and told to go to the state fire marshal's office? Isn't that correct?
To my recollection, I don't know. I don't recall exactly. But again, if they presented a enlargement in size that's not something I can permit, so I would have sent them for the variance.
Okay, so I still have some questions. For
Thank
the
you, Mr.
city, it
Capone.
doesn't have to be with the building inspectors, it could be to Mr. Mandela. Is the city concerned that their position would have a chilling effect on property owners seeking to make safety-related repairs for fear that making these repairs might subject them to significant additional costs?
Yeah, I don't think I can take a position on whether how the city feels about a chilling effect or not. I mean, this is a pure application of the code as it exists. If there's no provision that says you can waive this if it's going to create a chilling effect.
All right, and it's this 50% rule that Mr. Building Inspector was talking about. Can you tell us what section of the code he's addressing?
Sure, it's in the nonconformities section. Let me see if Mr. Janis, do you have it up right now?
I do not, unfortunately. I can find it quickly though. 249,
270, 49.
270, 49.
I believe it's 270, 49.
So that rule, by the way, is being represented to apply to the structure. Not the entire building, but the structure.
That's correct.
Correct.
So this is section 270-49.1. Any non-conforming structure or structure devoted to a non-conforming use shall be deemed abandoned if the structure is demolished or more than 50% of the structure is removed. Such structure shall not be rebuilt, repaired, remodeled, or altered unless the entire structure is made to comply with this chapter.
I would say that applies to the whole structure, not just the steps.
Well, now we've opened up another can of worms here. So
we've had some good arguments about structure. I know, Mr. Capone.
Well, if the structure is referring to just the steps, does that allow us to require improvements to the windows? Or is that part of something other than the structure that's subjected to the 50% rule?
Well, my view would be that the building official's interpretation is that if you're replacing less than 50%, the windows would not be required. But here you're replacing more than 50%, it can trigger these other requirements. I hear what you're saying, Mr. Townsend. This is, if we're looking at the stairs structure as a structure alone, how can it implicate something else?
Mm-hmm.
Man, it's a good question, but I do think that the building code, is a different code than the zoning code. The zoning code has the 50% rule. It doesn't mean you get to ignore the building code requirements of bringing the windows up to the fire rating if there's a replacement done of the stairs.
It's interesting because the building was determined to be legally non-conforming or grandfathered. That's why the stairs went back to the board in July, because the stairs as they existed right now, it's my understanding, were over, the whole thing was over lot coverage. So that, that was the zoning code aspect of it. I go back to, if we take the logic of what the city's saying, I think this is what Mr. Capone was suggesting, if it's 50% of the structure, it's illogical, because then you're replacing everything in that whole building, it seems to me. And I don't think anybody believes that to be the case. And then if we are, like we said with Mr. Mendelis, if we're not applying 270-49 of the code in this case, and we're back to the building code says that you are grandfathered and you can do this sort of work as long as you don't make it less safe. And I'm paraphrasing, but that's what we've done. We've put the structure back in and we've made it more safe by complying with the state fire marshal, and the building code says building them back up with better fasteners, better treated wood, a little bit wider, so the fire safety people can get up and down there. So that's kind of my point. When I said that I disagreed with Mr. Molina's statement that there's conflict in the code, that's the point. There's not any conflict in the code. We're now, with the variance you all granted, we're in compliance with the zoning code, and we're also in compliance with the building code.
Yeah,
so.
I'm going to throw this one out there. So we had a variance hearing, and this issue of the 50% rule never came up in the variance hearing. didn't come up by the applicant, didn't come up and by the building inspectors. Now, so does anybody who was there agree with me on that?
I agree with you. Did not come up, the 50%.
Didn't come up. We
Right.
granted variance. Nobody argued that this 50% rule was implicated. But today, we're hearing for the first time from the city, 50% rule comes into play. We were aware that there was going to be an issue with the getting the permit, but we understood it to be because it was a fire escape that was being built, and that the building inspector thought that the fire escape would trigger the need for these other improvements. So I'm not inclined to give great weight to the city's argument that the 50% rule is significant in our decision today, because it wasn't significant at the variance hearing last time we considered this property. That's just my feeling on this now.
Mr. Capone, if I may, the 50%.
Who's speaking? Who's speaking?
This is Mr. Janis.
Yes, ma'am.
The 50% rule only comes into play if they were replacing the structure in kind. That's out the window now, as they are building a completely new, larger than what existed structure. So the 50% rule really doesn't even need to come into the conversation at this point.
Well, I'm not sure I agree with that, but why don't I agree with that? Because if they were to make the so why do we start talking about it today? Who brought this up? I mean, it wasn't me. Somebody else.
It was only brought up because there was some talk about replacing the structure in kind, and you could replace the structure in kind until you got up to the 50%.
All right. So I'm not going to, you know what that leaves me with where I was 2 minutes ago. I'm not going to worry about the 50%. All right. Is there anyone else from the group that's from the board that would like to ask a question? No. All right. We're at the point, Joe Gottschall, is there anyone in the queue from the public who'd like to speak or ask a question? Speak.
Tom Evans has joined us from the public. He's the only.
All right. Tom, are you there?
I am here.
Okay, I'm going to ask our counsel to swear you.
Or affirm.
Or affirm.
Mr. Evans, could you give us your address for the record, please?
512 Newcastle Street.
Mr. Evans, do you affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Absolutely.
Please proceed.
Okay, Tom, go ahead.
The last 30 seconds discouraged me more than my life in Board of Adjustment, just so I say. So I'm going to cut to the chase. You don't have enough facts and evidence tonight to make a decision. That's my first statement, because I've heard enough tonight to know that I couldn't make a decision tonight. Also know that based on the evidence and facts, that if I were to weigh tonight, I would say that the appellant doesn't have a case. But I think they might have a case if people could speak clearly and if the facts were clear and provided in advance for the appellant to provide his case. This is not the most complicated case I've ever seen in my 22 years on Board of Adjustment as chair. And I don't think either it is complicated too much for the board or the attorney for the appellant is providing facts that are not clear, which is what I always think for them. Sorry. Or the evidence that is not accurate. This is not complicated. I think you need to spend your time, go back, look at it. I don't even know which way it's going to go. But you should weigh this clearly and maybe continue the case to get the facts and evidence so you can make the correct decision. Because I don't know what the evidence is based on what Vince is saying for the appellant. And I've read this and seen the property and know all the facts. There you go, guys. Good luck.
Thank you. Is there anyone else from the public who wishes to discuss this case today?
There's no one else on, sir.
No one else. Okay. So we've heard everyone from the public. There are no more questions. Anybody else have any final comments on this?
Could I ask a question of counsel,
Yes.
Mr. Capone? The Superior Court has indicated that the issuance or non-issuance of building permits is based on whether those decisions were arbitrary or unreasonable or potentially unlawful, are within the jurisdiction of the boards of adjustment pursuant to state law and section 324 and 327 and 328. Is there any discussion on this point from the attorneys representing the parties? Is that not the case?
Mr. Townsend, it's not a oh, go ahead, Glenn. Mr.
Yeah,
Menendez.
I'm not sure exactly why you're asking the question either, but I think that's a correct statement of the law.
I'm asking it because according to that International Existing Building Code citation from Mr. Manis, this board does not have the authority to hear the appeal.
Now, I think what he's quoting, just to be clear, Mr. Townsend, is that there is a provision in the International Building Code that says that the Board of Adjustment can't grant waivers, but it certainly can hear an appeal and evaluate the code interpretation. I think that's what the board is being asked to do here.
Okay, good. All right.
I would say, Mr. Townsend, I'm just looking at it real quick. It's actually in the city's code that gives us the authority to do that, not the building code. It's Article 18 of Chapter 102. It talks about the means of appeal, and it actually specifically gives the Board of Adjustment the authority to hear appeals from this situation.
Also correct, right?
I interpreted those remarks to mean that this board did not have the authority to hear the appeal. So my mistake for taking us off track.
I think the city, not Mr. Mendelis, but there was a suggestion by the city that they didn't have the authority, that we didn't have the authority, but that's not supported by the code, either the building code or the city's code.
Or the state code.
No, yeah, right, true.
Here's what I'm going to suggest. I am going to suggest that we take a 5-minute recess. It is 22 minutes to 3. So we'll come back in 5 minutes. And in that time, perhaps members of the board might be able to work on a motion or some way to resolve the case. So we'll reconvene in 5 minutes.
I'm going to need just a few more minutes, but I'll start my video as soon as I'm available again, but it'll just be a minute or two. If you'll just
Okay.
let Mr. Capone know. Thank you.
Okay, he heard you.
And I'm ready when everyone else is.
Fred, are you available yet?
I am.
Okay, Jan, still waiting for Jan. Okay, Jan, you there? You're muted, Jan. Jan?
No, I'm here.
Okay, you're muted. All right, so Fred is there. We're back on the record now. This is the time where we are going to decide this case. Is anybody prepared to offer a motion to resolve this matter? Let me turn the blinds off.
Jerry, for clarification, the motion is not our vote, correct, right?
The motion is not a vote.
Thank you. All right, let me try. I'd like to make a motion to uphold the applicant's appeal based on the stated fact that the city building inspector under testimony stated that the project was reviewed as a condo, and that was supported by the fire marshal reports. I would like to say I do believe there was communication breakdown in other exhibits, but based on those facts that the city talked to the or showed the fire marshal that this was a condo, and that the fire marshal report stated that it was a condo, and there was no further action, I'd like to make a motion to uphold the appeal by the applicant.
Is there a second to that motion?
I'll second the motion.
Okay. So, Fred, do you think that we have a sufficient motion there that would resolve the matter if approved?
I think it's understood that a motion to uphold the appeal would be equivalent to reversing the decision of the building official. I believe if that's what Mr. Brandt intended, I believe it is.
I would agree, Fred.
Right. And I just would remind you all that you stand in the shoes of the building official in making this decision today. That's your authority under the code to substitute your judgment for that of the building official in acting on this application.
Okay. So I'm going to go through the roll. I should have noted earlier that we do have a quorum here. We have 4 of the 5 members. We have Jan, we have Barry, we have Randy, and myself. So we do have a quorum. I'm going to ask you all for your votes, and I'm going to ask that you explain the reason for your votes at the time you give your vote. I'm going to start with you, Randy.
Oh, okay. I vote to indeed support the applicant's request and the reversal of the decision for from the building inspector. I actually found Mr. Robertson's explanation of following all the instructions that they received at part of the compelling reason, but the biggest one to me was this, the grandfathering clause, that there is nothing that is really substantially changed here, and except for something that is a slight safety improvement. And it seems to me it really makes sense to permit this to be altered just slightly rather than built exactly the way it is.
Okay. Jan?
I vote to support the building inspector's decision. I believe that this obviously is a fire escape, and that the health, safety, and welfare of the inhabitants is most important. And my understanding is that when there's conflict between the building inspector and the fire marshal, the more stricter of the code applies. So I do think that, so I do uphold the building inspector.
Barry?
That's a no vote on the motion.
Right.
Mm-hmm.
Right. I am going to vote no against my own motion. I believe that this is a fire escape. It meets the requirements of it. I'm saddened by the fact that we have to get, what appears to be a financial issue, a burden, on this structure. I have to go against my own motion. So I'm voting no based on the fact that safety is paramount in this situation, and it should be built in accordance to the fire marshal code.
And this is 3 votes are needed to succeed, right? I'm going to vote along with Randy on this one. I think that the fire, they were seeking to improve the fire escape, and by imposing these extra building requirements on the owners of the property, it would, in effect, it's not helping the safety of the people. They were seeking to put in a better fire escape, and now if we were to go along with the building inspector, they'd be stuck with a fire escape that is less safe. So I think that my concern goes to improving this exterior stairway. So we have a 2-2 vote. Based upon the rules of the board, I don't think that the appellant's case is carried today. Would you agree with me, counsel?
Yes, sir.
All right. Well, that concludes the matter today. That's our first hearing. Okay, Mr. Robertson, thank you for your participation. Have a happy holiday.
Thanks, you too. I'm just going to point out, I wish I had a full board. This has been the second, maybe the third board meeting where we haven't had 5 members of the board, and
Well, if I were to tell you that there's a very sad reason why Mr. Cassell couldn't show up, I would be telling you the truth. It was the sudden, unexpected, and very sad.
Okay. No, fair enough, Mr. Capone. I just want to say that. Happy holidays, everybody, and Happy New Year. Look forward to seeing you all in 2021. Thanks.
Mr. Chairman, could the court reporter have 10 minutes, please?
Yes, you may. How you doing, Barry?
Good, Jerry. Thanks for asking. Out in Pittsburgh.
Oh, really? Okay. Are you stuck in Pittsburgh, or are you
No.
gonna be coming back?
Now we're here for over Christmas. We'll come back quarantine once we come home.
All right, so Glenn's not there yet. Madam Court Reporter, you back ready? Good, this is Glenn.
I am, yes, thank you.
Joe, is our next applicant on board here?
I'm not certain. I have a 703 phone number that I will unmute, and they can identify themselves. Sorry, guys, I'll hang up. Sorry.
I don't know who that was, Joe. It looks like they hung up.
Well, if they call back, I'll let them back in.
They must have been watching the last session. So Joe, are you still trying to reach them?
She had a kidney stone removed about a week ago.
Oh.
And subsequent to that, she was told she needs to come back for another procedure, which was scheduled for the 23rd.
Mr. Neal?
Yes.
You are currently on the meeting with the chair, Jerry Capone. If you would just tell him what you told me. You don't have to go into medical details.
We're scheduled for the 23rd, and I was planning on attending, but my wife had a kidney stone removed about a week ago, and she's been notified that she needs to come in for a follow-up procedure on the 23rd, midday. So I'll be her attendant and chauffeur for the entire day. And I left a message with Ann Womack this morning that I'd like to just postpone for a month. I'm actually anxious to do this, but it's just the timing isn't working out.
All right.
So
I'm sorry to hear all that. Ms. Womack wasn't here today. We didn't get the message. We're sorry to bother you and during the situation.
You're cracking up and I cannot hear you.
Yeah, we're sorry you won't be able to make it. Ms. Womack was out today, so.
I see.
Yeah.
Okay.
All right.
I'm in favor of giving you the
any problem with deferring I'll just wait then and hear from you again.
Well, we'll let him know right now.
Let me know. Do you want to go on the record?
Yeah, let's go on the record. Okay, so Mr. Neal has contacted the board and advised that due to a medical problem with his wife, they're not able to proceed today. He's asking for a 1-month continuance. Is there anybody that opposes giving him 1-month continuance? No.
No.
So, Mr. Gaccio, you can tell Mr. Neal we'll schedule this for next month, okay?
All right.
Okay,
Mr. Neal,
thank
did you
you.
get that?
Yes, I did. And thank you very much. Was I the only case for the 23rd, or
Oh, no.
were there
Oh,
others?
no.
All right.
All right. So, first of all, I'd like to wish everybody a happy holiday season. I think
Thank
we've
you, sir.
concluded all our business for today.
We'll get back to you.
Jerry, do you want me to make the nominations?
Thank you. Yes, we didn't finish the business. So the other thing
Excuse
we
me, do you still need my record?
Yes.
Stay on the record? Okay.
So what we need to do is elect a slate of officers, or we could do it individually or by slate. Is there anybody that has a motion to make? Jan?
I do have a motion.
And what's your motion, Jan?
My motion is I'd like to nominate Jerry Capone to be chair, Barry Brandt to be vice chair, and Walt Cassell to be secretary of the Board of Adjustment.
Okay, is there a second to that?
I'll second that.
Okay, all those in favor signify by saying aye. Aye.
Aye.
All right, that carries 4-0. Now we're done with our business. Please, everybody, have a safe and Merry Christmas and a Happy New Year, and we'll see you in a month.
All right. Happy holidays, everyone.
Happy holidays all. Thank you.
Be safe.